Uh, Good afternoon and welcome to this new episode of the Diary of a Lawyer. And today we are going to be briefly talking about the Geneva Convention on the Rights of Refugees. Um, we often hear these issues being discussed in the media, in the public sphere, but we never really hear what the law actually says. And so, what I'm trying to do is just give a brief factual, contextual background of what the convention is, and not really go into the either side of the debate regarding the particular issue. I just focus on what actually the convention says. It's a very long convention, so I just try to summarize it and put it in more malleable terms as far as reasonably possible. So, just a brief background. Obviously, according to the United Nations, the history and the context of the convention states that this was grounded in Article 14 of the Universal Declaration of Human Rights in 1914, which essentially recognizes the right of persons to seek asylum from persecution in other countries for reasons of either religious, political, ethnic, and other grounds where people need to seek safety and persecution or of war to go to other countries. And the United Nations conventions was adopted relating to refugees was adopted in 1951, and it's really, according as the UN says, is the centerpiece of international revenue protection currently today. The convention entered into force on the 22nd April 1954, and it has been very often the subject to only one amendment in the form of a 1967 protocol, according to the UN and public records. The 1951 convention is, as a post Second World War instrument, was originally limited in scope to persons fleeing events occurring before January 1st, 1951, and within Europe. But the 1967 protocol removed these limitations and thus gave the convention universal coverage, and it has since been supplemented by refugee and other subsidiary protection regimes in other regions, as well as through the progressive development of a growing body of international human rights law. And this is echoed by the United Nations human rights bodies, as well as the Refugee Council. So the 1951 Convention also consolidates previous international instruments relating to refugees and provides one of the most comprehensive codification of the rights of refugees at the international level, in juxtaposition to earlier refugee instruments. These had applied to effectively specific groups of refugees, but in the case of the 1951 Convention, it endorses a single definition of quote-unquote the term refugee in Article 1. And the emphasis of this definition is on the protections of persons, as I said earlier, alluded to earlier, from political or other forms of persecution. And therefore, a refugee, according to the Convention, is someone who is unable or unwilling to return to their country of origin, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, and or political opinion. Now, it's important to note that the Convention is both a status and rights-based instrument and is underpinned, according to the United Nations, by a number of fundamental principles, most notably non-discrimination, non-penalization, and what they refer to as non-refoulement. And I'll spell that: non-refoulement being REFOULEMET. I think it's probably connected to the interplay between the French and the English language. And the convention provisions, for example, are to be applied without discrimination as to race, religion, or country of origin. And recent developments in international human rights law also reinforce the principle that the convention should be applied without discrimination as to age, disability, sexuality, or other prohibited grounds of discrimination, which are also generally referred to as protected classes. The convention stipulates further that subject to the specifications, very specific specifications, refugees should not be penalized for their legal entry or stay, and this recognizes that the seeking of asylum can require refugees to breach immigration rules. And this is, I'm reading verbatim from the United Nations document. And prohibited penalties might also include being charged with immigration or criminal offences relating to the seeking of asylum, or being arbitrarily detained purely on the basis of seeking asylum. Importantly, the Convention contains various safeguards against the act's expulsion of refugees, and the principle of non-refoulement is so fundamental that no reservations or derogations may be made to it, according to the United Nations. These are their own words. And it also provides that no one, quote unquote, shall expel or return, brackets, refouler, a refugee against his or her will, in any manner whatsoever, to a territory where he or she fears the threats to life or freedom. So that's very clear, it's self-evident. And finally, the UN concludes and states that the Convention lays down basic minimum standards for the treatment of refugees without prejudice to states granting more favorable treatment. And such rights include access to the courts, to primary education, to work, and the provision of documentation, including a refugee travel document in a passport form. Excuse me. Most states parties to the convention actually issue this document, which has widely been accepted as the quote-unquote Nansen passport, an identity document for refugees derived by the first Commissioner for Refugees, called Fridtjof Nansen, in 1922. The convention does not, however, apply to all persons who might otherwise satisfy the definition of a refugee in Article 1. In particular, the convention does not apply to those for whom there are serious reasons for considering that they have committed war crimes or crimes against humanity, serious non-political crimes, or are guilty of acts contrary to the purposes and principles of the United Nations. So crimes against humanity or war crimes may determine where the refugee grant or not of an individual. The convention also does not apply to those refugees who benefit from the protection or assistance of a United Nations agency other than the UNHCR, such as the refugees from Palestine, or fall under the auspices of the United Nations Relief and Works Agency, also known as UNRWA. Nor does the convention apply to those refugees who have a status equivalent to nationals in their country of asylum. So apart from expanding the definition of refugee, the protocol obliges states to comply with the substantive provision of the 1951 Convention to all persons covered by the refugee definition in Article 1 without any limitation of date. Although related to the Convention in this way, the protocol is an independent instrument, accession to which is not limited to state parties to the Convention. Under the Convention and protocol, there's a particular role for the UNHCR, which we shall just briefly go over, which is that it undertakes to cooperate with the UNHCR in the exercise of its functions set out in the Statute of 1950, along with a range of other General Assembly resolutions, and in particular to assist the specific duty of supervising the application of the Geneva Conventions. And by its statute, the United Nations Human Rights Refugee Agency is tasked with, among others, promoting international instruments for the protection of refugees and supervising their application. And the fundamental importance, according to the UN, HCR, and enduring essence of the Convention and Protocol is widely recognized. And the document says that in 2001, states issued a declaration reaffirming their commitment to the 1951 Convention and the 1967 Protocol, which slightly upgraded the 1951 Convention, and they recognize in particular that the core principle of non-refoulement is embedded in customary international law, and that's important. That means it is part of international law for which all member states abide by, and moreover, or should abide by. Moreover, the General Assembly has frequently called upon states to become parties to these instruments, and the accession has also been recommended with other organizations such as the African Union, the Organization of the American States, the Council of Europe, etc., etc. And today there are around 147 state parties to one or both of these instruments. And in light of the growing recognition of the fundamental significance of the Convention and the protocols for the protection of refugees, according to the UN, and for establishment of minimum standards of their treatment, the UN calls upon third parties and states that it's important that their provisions be known as widely as possible, so that both by refugees and all concerned with refugee issues. In other words, this calls for the education and advocacy and advice of the protocols. And that is the general overview, but I think it's also important to read, to go through the preamble, to accentuate, to emphasize the importance with which these protocols were, the importance of and significance to international law and generally the international world order, in terms of the dealing with some of the catastrophes that the world faces, such as war, persecution, etc. So some of the preambles are important, and I'll just quickly go through them, and they reflect the many articles which we can, in the interest of time and brevity, we will not go through here. But essentially, the preamble states as follows. It starts A, B, C, D, E, and it goes through the various headings for the preamble. So starting with A, it says the conference considering, and I'm reading verbatim, that the issue and recognition of travel documents is necessary to facilitate the movement of refugees, and in particular their resettlement. It urges governments which are parties to the Intergovernmental Agreement on Refugee Travel Documents signed in London on 15th of October 1946, or which recognize travel document issued in accordance with the agreement, to continue to issue or recognize such documents. Essentially, A deals with travel documents for people who are classified as refugees, and then B, it deals with the unity of the family, the natural and fundamental group unit, which is described as of society, and also as an essential right of the refugee, and that such unity is constantly being, just because it's constantly being threatened, so it calls on parties to member states to ensure that that right to family is respected, um, and protect refugees who are minors, in particular unaccompanied children and girls, with special reference to guardianship and adoption. Then C deals with welfare services, which describes as the moral, legal, and material spheres refugees need to help, the help of welfare services, especially that from civil society, and urges governments to facilitate, encourage, and sustain the efforts of properly qualified organizations. And then D deals with international cooperation in the field of asylum and resettlement, and it describes that many persons still leave their country of origin for reasons of persecution and are entitled to special protection on account of their position. And it calls, or as it says, recommends the government to continue to receive refugees in their territories and that they act in concert in a true spirit of international cooperation in order that these refugees may find asylum and the possibility of resettlement. And these are, direct references from the preamble. And then E deals with the extension of the treatment by the convention, which says that in the conference expresses the hope that the convention relating to the status of refugees will have value as an example, exceeding its contractual scope, and that all nations will be guided by it in granting, so far as possible, to persons in their territories refugees and who would not be covered by the terms of the convention and the treatment for which it provides. And those are the main preambles, and it lists the various signatories of the conference then, which was signed by the president of the conference, Kanad Larson, the vice president of the conference, A. Hammett and Talat Miras, and the secretary of the conference, John P. Humphrey. And that's really the brief summary of the refugee conventions, the initial one 1951 and the 1967 one, which sort of upgraded, was the initial 1951 convention, and essentially deals with the rights and protection of refugees or people fleeing persecution for either reasons of their political views, religious views, nationality, ethnic origin, and was later upgraded to include protection for other issues such as sexuality, sex, etc., etc. And so that is it in a nutshell. That is just specifically a summary of what the Convention on Geneva Convention on Refugees is about. And so I just wanted to make sure so that people have a view, a clear summary of what it actually is. We're not taking sides. We're just focusing on the legal issues here. And thank you for listening for yet another episode of the Diary of a Lawyer, and we shall speak again soon. Thank you and goodbye for now.